slime kill people, and I don't want to fight nobody. If they show this to the jury, it's over. They should not be allowed to show this to the jury, bro. This is someone that, it's hearsay. This is like someone we don't even know who this is that he's talking to right here. This could be fake. Day 24 of the Young Thug YSL RICO trial was a complete failure. The defense lawyers object to pictures of Christian Eppinger and 10-year-old tweets from Young Thug. The state is introducing all this to show gang affiliation. Brian Steele then argues that he should be able to play Young Thug's NPR performance under the rule of completeness. Yeah, this day was completely wasted. The jury doesn't see any testimony. And go ahead and take a wild guess on how the judge rules on this. Do you think he's going to rule in favor of the defense? Come on now. He's never going to do that. All right, subscribe. Here we go. First look at Thug today. He's got a nice green jacket and red turtleneck on.
My understanding and belief, it's a picture of my client, Mr. Stillwell, with a gentleman who's now deceased. His name is Quentin Porter. I'm going to object to the admission of this photograph as irrelevant.
What's the basis? Or you said it's irrelevant?
Irrelevant, prejudicial character. Mr. Porter, I believe the testimony was already provided by Officer Belknap. Mr. Porter is a gang leader, or was a gang leader. Discussions with Investigator Belknap earlier this morning. My understanding is he would say that there's nothing intrinsically gang related about the picture itself. It's just merely that my client is in the same picture. Mr. Porter, I believe that it would be improper include responses to this post, which include heart emojis and different emojis, and as well as the number of likes. We don't know who those people are. Those are out-of-court statements with no exception, hearsay exception. I'm objecting to the admission of the picture as a whole, but if Your Honor should admit the picture, there's no need to admit the statements of other individuals.
That was Shannon Stillwell's lawyer objecting to a certain picture with Shannon and someone who died who was a gang leader. Now Thug's lawyer's coming up. The jury's not there, obviously. They're on recess right now.
I'd like to object to, it's a photo of a text message conversation. It's between, I believe, the phone of the Facebook account of Mr. Eppinger, who's not on trial, but he is a co-indictee, and someone else. And I believe in the words of an unknown person, they wrote "slime kills people," and I don't know who that person is, and I don't know the context of that, and therefore it would be hearsay and prejudicial. That's a photograph of Mr. Eppinger standing in a wooded area with a firearm on his waistband. There's no gang symbol being shown. There's nothing about why that should come in, and it would be prejudicial to the people on trial, including Mr. Williams. Is a photograph of Mr. Eppinger wearing a black beanie, written on it from his Facebook. All these are Facebook, Your Honor. And it says FUK, and then new word DA, and then new word cop. And then there's a overt act where Mr. Eppinger, God forbid, shoots the police officers on video. This comes before it. It would be very prejudicial to people on trial. I don't see that he's trying to predict that that's what he's going to do, and he's not here to cross-examine either.
So he's objecting to a bunch of shit about Christian Eppinger, who isn't even on trial anymore, which I understand. A lot of it seems irrelevant to me, in my opinion, but...
Is Mr. Williams' alleged tweet. This is Mr. Williams' Twitter account, and it just says "Love Rock," which is capital R-O-C, and then F-A-M.
You're pulling out tweets from 12 years ago of him saying, "I love rock crew."
There's a number of tweets, and I will object to all of them coming in unless I have the right to cross-examine and place them in context. And Your Honor, I'd like to give you just 2 cases with the court's permission.
Maybe he wants to show other tweets for context, maybe, or something?
Cannot come in unless Mr. Williams testifies, and I disagree. The Sound Court did not let me play the song Dropping Jewels, and it's Morales, M-O-R-A-L-E-S versus State. Your Honor, it says Morales also argues that in light of the admission of incriminating portions of his statement into evidence, the trial court should have also admitted the earlier portions of that statement under the rule of completeness, because the earlier portions of the statement are self-serving declarations. They are not admissible as admissions against interest and remain inadmissible hearsay. And the court wrote, "We agree that Morales' entire statement should have been admitted under the rule of completeness, but conclude that the error was harmless."
So you just cited a case from 2016 of Morales, I believe the name was, on the case. He's saying that under the rule of completeness, Thug's full statement needs to be provided and shown to the jury, which I kind of agree with.
That he had sex with the victim and ejaculated inside her, quote, "little," end quote.
Oh, whoa. He's talking about another case, but something just...
Such a result would ignore Georgia's longstanding rule of completeness, which provides that when an admission is given in evidence by one party, it shall be the right of the other party to have the whole admission and all the conversation connected therewith admitted into evidence.
Brian Steele kind of cooking right now.
As the Supreme Court of Georgia has recently noted, the rule of completeness prevents...
You'll read me the entire case? I got it.
Okay, and I apologize. This is so important to our case, and the state's argument to you, and I'm not saying it was unintentional, but it's wrong. The rule of completeness trumps.
It seems like from looking at Morales, it does.
And then I just gave you, just for the...
Judge cut him off, but he's siding with them, I believe. We can all agree that showing certain tweets out of context, kind of unfair, right? I mean, it's a f***ing tweet. Why are you tweeting, Thug? I mean, I know it was 2011. He wasn't famous yet.
But if the state is going to get into any Mr. Williams' Twitter, with the court's permission, I need to put him in context. That's my argument.
So you're saying that you wish to admit the entirety of the... under the rule, under 106?
Yes. I'd like to recall Mr. Stevens to play Tiny desk from NPR.
Hey, by the way, these hats are $20 on CUFBOYS.com right now. I'll ship it within 24 hours. There's only like 15 left too. So judge just said now they're going on lunch, and now they come back 2 hours later. This whole day has been wasted. Like they wasted the first 2 hours. They just talked for 35 minutes, then wasted another 2 hours.
And when the state presented his case, in this case, they only presented the second portion, which is when he admits to being the victim. They did not put in the initial part where he first denied it. And so what the courts have said is even if that was a self-serving statement, that because it gives context for the rule of completeness in that particular instance, it was relevant to the second portion, so that the state should have put in that entire statement. And that was a recorded statement, his interview. This is very distinguishable from Twitter and tweets, Your Honor.
So she's saying since it was a recorded interview and this guy admitted it in that Morales case, it's different because these are tweets from Thug.
Twitter is a social media site or instrument in which, if the court is familiar with it, that there's kind of random thought that one would...
You don't think I know what Twitter is?
I know you know. I just don't know if you
Then
want
why
it
would
as
you
much.
even say that?
Because I don't use it as much.
You think I don't know what Twitter is? This judge is kind of funny sometimes, bro.
Twitter is random thoughts, random streams of consciousness that may happen. However, what they're asking to do is, there's a tweet that says the sky is blue. Then there's another tweet, maybe that same day, that says I went to the store. The I went to the store tweet has nothing to do with the sky is blue tweet. Qualifies or places into context the tweet we put in.
Hey, do we know what tweets y'all are going to put in?
We do.
How many tweets you have?
There's a number of them.
I don't like that.
So he says, I love my rock fam, and then he ats like 4 people or 3 people. If you guys remember old Twitter, this is him quoting someone else. He never typed up this. This isn't his tweet. He said, boy, stop, and never that. That's all he said. This is a quote tweet. He ain't even the one that tweeted it.
Now, if there was something that needs to be put in context for the I love my rock fam that we did not put in, then the state, once we know what they want to put in, then we can discuss that then. But if it does not have anything to clarify I love my rock fam, then that does not come in.
Okay, back to my original question.
Yes.
How many tweets we talking about?
Okay, I'm sorry. There are 82 tweets total.
82.
Yes.
82 tweets. 10 plus years ago, probably majority of them. So that's Shannon Stillwell on the right. And this is Quentin Porter, who passed away.
Picture, Your Honor, is posted on OG.bull. The state believes that OG.bull is the Instagram account of Shannon Stillwell. We have, in this case, talked about Quentin Porter being a founder of Rock Crew. We believe that this picture is relevant because during the course of testimony for, I believe, Trontavia Stevens, when we asked if any of the individuals here were either associated with Rock Crew or knew about or hung out with them when they were part of Rock Crew, he said they may come to the club with us, but that's about it. What we believe is, and what part of the state's theory is, that YSL transitioned from Rock Crew to YSL, and that this picture shows, one, that there was an association, at least with the initial Rock Crew leader and founder, who was Quentin Porter, and we believe that is a relevant piece of evidence that the juries could use to make whatever determination that they believe to be.
So he's a leader of Rock Crew, and this is Shannon Stillwell, trying to show that Shannon Stillwell was boys with someone in Rock Crew.
To show that there was an affiliation with Rock Crew. We do not believe Mr. Stillwell was a part of Rock Crew, but we definitely believe that this shows the initial parts of the relationship with Rock Crew in transitioning into YSL. So we believe it's relevant for that purpose, and so that's why we plan on introducing.
I mean, this is complete guilt by association.
I believe I'm gonna admit the photograph, period, because it does show association and the development of the state's position of the case in terms of Rock Crew and its association with YSL. So it's relevant for that particular purpose.
This is just me speaking. I know you're in charge, Judge, but my view is we need to redact the photos, and we need to redact that there's 301 likes.
Okay. So everything but the date and the first 2 OG Bull would probably be okay.
Your Honor, look at Exhibit 1W. This is the Facebook post of Christian Eppinger. Clearly, you see that he calls himself YSL Brisk. We believe that the testimony will come in that he is associated and is a member of the street gang YSL. So these Facebook posts and messages would come in to show his association with the enterprise, clearly by his name being YSL Brisk as his Facebook account, and as Investigator Belknap will testify to, that he's changed his name is Christian Eppinger, that he's changed his name from C to B on here, consistent with what we have alleged that members of the Bloods do, as well as members of YSL do, because they have association with the Bloods.
So a lot of people are probably annoyed by this. They're just trying to prove that they are in a gang. That's what this is. This isn't like real evidence of like proving that they committed a crime. They're just showing association with YSL. It is cringe and stupid, but that's what they're gonna do, bro. They're just trying to prove association with Christian Eppinger.
Where he has the YSL, what we believe to be the YSL symbol that he is wearing, and wearing money green. Again, putting up some blood here. I believe this is 4W is the post that Mr. Steele has asked that we remove. And this is a post that Christian Eppinger put. And what he's placed this on his Facebook post for, it's a public site, so for the world to see. This shows that the nature of the enterprise, the violence of this enterprise. We allege that this enterprise involved in violent acts to include murder, aggravated assault, and armed robberies.
Hold on. Christian Eppinger did not post this, bro. He says, what you mean you ain't finna get killed? Someone replies to this, slime kill people. and I don't want to fight nobody. If they show this to the jury, it's over. They should not be allowed to show this to the jury, bro. This is someone that, it's hearsay. This is like someone we don't even know who this is that he's talking to right here. This could be fake. This could be not real. This could be two friends arguing like as a joke, out of court hearsay.
He also, we believe, or we will argue, that when Christian Eppinger posted this post, he posted to instill fear or to show fear amongst anybody else. And that is our argument as to why this post is particularly relevant, as to why the jury should be able to see that he posted on his public page this tweet. And it is to instill fear into anyone else seeing this tweet, what slimes could do, may do, and the fact that you should be fearful of that. And so we believe that that goes, and that's a part of the enterprise and the nature of that enterprise. And so we believe that that all goes to show the nature of the enterprise. Mr. Steele objected to this photo coming in because he has a gun in his hand. Gun in his pocket. But again, he says, keep it on me, waiting for to try me. Again, Your Honor, posted on his public Facebook page, him with a gun, again, showing the nature of this enterprise. Again, that they are violent, that they promote violence, and they intend to post these pictures to promote fear in those in the community or those who can be able to see this post.
Or he's just violent. I mean, I don't see him with young Thug in this picture. Where's Thug at? Maybe this guy's just violent.
Next post, next 7W, again, him throwing up the YSL sign. I'm done talking, anybody wants smoke. Again, Christian Eppinger, same thing, YSL birth. And this is just repeated behavior of Mr. Eppinger. Again, his association, he has on a red bandana, associating himself with YSL, the gang. I believe extremely important. This is a post that Mr. Eppinger posted in June of 2015 where he puts a new ink. And on the side of his face, he has tatted on his face, YSL, the gang. Your Honor, you've heard evidence in this case that in May of 2016, he robbed Ms. Taravia Hill. And we believe that there's a marking on his face that's been introduced in evidence, which we contend is this YSL tattoo. We believe that there will be testimony about the open and notorious nature of the fact that he robbed a woman in broad daylight with this YSL tattoo can be evidence of activity and furtherance of the gang. In 2022, to have shot at Officer Rogers when he was being apprehended for an armed robbery that he did.
This man, Christian Eppinger, is an absolute savage, bro.
No, I would like for us to begin to start today. The jury has been here all day.
I like it too, but here's the challenge, and here's my fear. We're going to put this jury in the box, and then as soon as we get started, I'll give it 10 minutes. Oh, Your Honor, can we approach? This has been taken out of context. It hasn't been told exactly the way I want to. So I'd rather have you all go through that and just tell them, hey, we got more work to do. Have you sanitize and agree upon that so the examination goes smoothly. What I don't want to do is for the next 2 hours is eat it up by you all having multiple bench conferences, which is what I think is going to happen.
This move from the judge is honestly smart, just trying to get it situated before they bring the jury in, and then they do a sidebar and just it gets delayed even more. And
Mr. Steele's presentation of the case law that he gave to the court earlier today in no way changes the court's analysis of whether or not he's allowed to play his client's song. Cannot make a blanket statement that the state misrepresented something, so that allows him to just put in all of his clients' self-quoting statements. Number one, he has not met that burden. I remember that the court asked the state when we were discussing it, which version was different. One, the case law is clear that Mr. Steele, the defendant Williams, bears that burden of showing to the court what part of what the state presented to the jury, and we read lyrics. We read actually the entire song. Let's just be real clear. We didn't leave out anything and we did not misquote anything. The defendant bears the burden of showing to the court what was misquoted or what was misrepresented or what was taken out of context. Then he bears the burden of showing to the court what the right statement was. So in other words, he's arguing that we misrepresented his client's mindset. We didn't represent his client's mindset. And what he is attempting to do is to try and present his version of evidence of his client's mindset, which is why the rule was invented, because that would keep us from being able to cross-examine his client if he did it without putting his client on the stand. And the rule of completeness only allows him to get in what he can show was evidence showing that the state made a misrepresentation as to the words of his client's song. I said that his client said something to the effect of the sky is blue, and his client actually said the sky is red. He has to say, Your Honor, she said the sky is blue. She attributed those words to my client. Here's where she did it, and here's where I can prove to you that he said the sky is red. He cannot put in the entire song because he claims that my intonation was wrong, because the only thing that we were presenting to the jury is the fact that the words to the song were what Trontavia Stevens said that they were. Ironically, when Mr. Steele crossed Trontavia Stevens, he said the same words that he stated the state had said.
Bro, you read the lyrics to a witness completely out of context and emphasized cuss words and bad words in front of the jury.
Fix that misrepresentation. He can show a line. He is only entitled to show the line. I didn't play a version of his song. I didn't put in a video. I asked the witness words. And so he can in turn go back and ask the witness words. The rule of completeness does not allow him to go and put in that video, which is in itself a self-quoting statement that the state, number one, didn't put in. He, at the most, one, should be required to identify the lyrics that the state read wrong. What he is doing is wanting to put up a video of his client singing in a concert and a venue and confusing the issue because the state didn't present a video. So there's no issue about a video. He would have to show what lyric we said wrong, and then he's only entitled to give to the jury, state to the jury that lyric. Video is an entirely separate and different conversation, piece of evidence, statement, self-quoting statement that his client has made. There's nothing that he is rebutting. There's nothing that he is correcting by putting in a video of his client singing the song when we never put in music. We never put in a video. It doesn't, the rules don't allow him to do what he's trying to do.
Well, you quoted his...
I quoted, and he has to tell you what I quoted wrong. And he has not done that. He has not done any of it. He's not even tried.
This is crazy. The judge is going to do it. The judge is going to give in. He's not going to let him play the song, which is crazy when she can quote the song and say all the lyrics, but they can't just play it for the jury.
I didn't say anything wrong. That's why he can't tell you what I said wrong.
All right, Brian Steele, back up. Let's see what he says.
Your Honor, these are a recorded musical lyrics song, and what the state did was they took it with their own inflection of voice. They stressed certain phrases, or mostly curse words, and yelled, my word, yelled at the witness, are these the songs? Are these a word? A song, this is not a confession. This is not a statement to a detective. These are protected speech unless, deemed otherwise. Under the rule of completeness, the reason I want to play them is to show the jurors that this wasn't a yell like Miss Love did, and that's my word, and that the phrases were skipped. There were lyrics that are skipped, and my colleagues from Law and Crime, if you would accept that, they have the actual, what I believe the actual voice of Miss Love and the order of how she asked the lyrics. She did not ask all the lyrics of the song. And my understanding is that she transposed some of the lyrics before other lyrics.
It also depends upon what version was played, because artists sometimes release regular version, extended version, snippets, whatever else. So we got to figure out to begin with which version you're talking about.
So the versions, my belief is the version that the state wanted, which was States 40, which was the album cover and then the song being played, if you could recall. Those are going to be the identical lyrics that Mr. Williams did in...
How do we know that?
I listened to both.
But you all don't. You can't tell me with specificity whether or not that is truly the release song or if it's some other release for YouTube.
See, I look at it differently. I look at it like I try to bring the pure evidence. I have Mr. Williams live on recording singing that song. It can't get more pure than that. What happens, and the court may know this and just say I understand. Once an artist, in this case Mr. Williams, does a song in a studio, other people then get involved. They can actually change. Sure. Okay. So I took the most pure statement.
That's a good point that the performance is strictly thug, but there is a backtrack of the song playing in the background, I'm sure, but...
and that's what I wanted to show. Also, the words are clear. Mr. Williams is singing clearly for the jury. That's the whole point. Love was asking about lyrics, asking about words.
So what is your issue as to the rule of completeness? Are you saying that Ms. Love has misrepresented, or not misrepresented is a poor word, is not stated the correct version of...
She stressed certain words that were not stressed by the statement.
What does that have to do with anything?
Because
that's her license as counsel.
It's my license as counsel to put in the correct. If somebody.
But that's for you to examine, okay? And that's certainly so. But the rule of completeness doesn't cover that.
Yes, I think it does, because
Have you got any case law to that effect?
Yeah, I think that it's out of context. She left out. Also, when I say she, I apologize. Miss Love left out. I taught my son how to stack that SHI blank to the ceiling. Yeah, they complimenting my new Rolls Royce, TV in the front of that MF like a tour bus. Spirit of ecstasy got me feeling so blessed. You see, she left that out.
Damn, she leaving out stuff, bro. She tried to say she never left anything out.
I just hope you find another life. Won't pick you up if you ever fall, right? Ain't no more reminiscing, ain't no more judging, no intuition. Tell me why I'm living, tell me why I'm remaining here. I was smoking Scotty but not Pippin. I taught my son how to stack that SHI to the ceiling. And when you look at this in context, and I understand everyone has their own interpretation of art, Mr. Williams is teaching. That's the name of the song. He's dropping jewels, as you may remember. That's an expression. It means giving wisdom. And he's teaching whomever, the audience. And you need to watch yourself. And if you live long enough, you may be in a situation you're going to have to defend yourself. And it goes through all these statements of there are problems in the world. Inflection. She should have played the song if she really wanted to.
It's the state's case to present the way they see fit.
But then I have a case to present too.
Okay, and I understand that, Mr. Steele. You're Mr. Williams' advocate. I understand that. I believe that the correct thing for the court to do for the rule of completeness would be to admit the stanzas or verses that were not mentioned by Ms. Love. Since we didn't play a video, you can certainly add or introduce those particular statements. But playing the video, I don't think in its total entirety would be proper.
Okay, and I understand that's your thought or maybe your ruling, but I will take respectfully objection to it because I want it to come out as an entire song. This is not a statement to a detective. The song is not just words. It's a composition. It's a melody, and it's the inflection. And that's really what bothered me the most.
I know it may bother you, but that's her examination as counsel. It'd be like the same thing. All of us have different pitches and timbres to our voices. It'd be the same thing as her.
Now it's going to be in the jury's head that his song sounds that way when it doesn't at all.
We can admit the entirety of the song in printed form, and I would suggest maybe you do that. But you need to get the version that is complete.
I would like to play it because handing somebody a piece of paper and marking it as exhibit, it is a song.
I'm not going that far at this point in time, Mr. Steele. You've asked me, no harm in asking. But I'm going to deny that motion.
The judge basically just said, all right, shut up. I disagree with that, bro. That was too far. She shouldn't be able to screen the lyrics in front of the jury and emphasize cuss words and just say, is that the lyrics to Slug? The defense can't just play a performance to show how the song actually is. That's kind of crazy, but whatever. Oh, man. Comment down below what you guys think. This trial is just such a circus. The jury didn't even come in today. Hit subscribe. Follow me on Twitter and Instagram. Love you guys. Peace out.